Good morning, everybody. It's 10:02 and it's Hilda Gann with COVID-19 Tough Decisions for Business Owners. And I have with me today my guest, Stuart Rudner. We are going to talk about HR and HR law because there are so many things going on in COVID-19 where having to make decisions with regards to staff is paramount. And as business owners, as HR decision makers, it's time for you to understand what you need to do and to have somebody who, like Stuart and myself, to give you some tips and advice. So next slide. Today is episode 24, and we started this actually on March 23rd and started with 2 episodes a week where we wanted to help business owners and managers, decision makers, to really understand some of the tough decisions that they were making. If you like us, tag us at People Bright or at hashtag COVID-19 TDBO. Next slide. So a little bit about myself and my guest, Stuart. I am the founder and president of People Bright Consulting. It's a full service HR firm, and what I'm really proud about is a concept that I created called Connect with RevUp. This really helps managers and teams to really build a stronger work culture. I'm passionate about building healthy work cultures. This is one of the reasons I started COVID-19 webinar because I really want to help companies understand what they need to do to manage during these very difficult times. A little bit about myself. My husband and I actually had an engineering company before I started People Bright, and we grew it from 2 people to 125, 7 offices in Canada. And we were recognized as one of the top 10 best workplaces in Canada. So that's where my passion is about helping build healthy work cultures. I have a diverse background, but I'm going to go to the next slide now and introduce Stuart. Stuart Rudner is the leading employment lawyer and mediator and the founder of Rudner Law. He has had many accolades, one of them being the best lawyers in Canada in the area of employment law. And he's been a top 3 employment and labor boutique in Canada HR Reporter Reader's Choice Award for 2019 and 2020. So recognized in the field. So I'm so happy to have him here. He is the author of a book called You're Fired, Just Cause for Dismissal in Canada. And it is one of the top legal social media influencers. I mean, Stuart is one of the top media influencers, and you can actually see him regularly on various media throughout this COVID-19 in particular. So I would love to introduce you to him. He is a winner of the Canadian Employment Law Firm for 2019, and I'm so pleased to have him here. The next slide. So just a brief overview of what we're planning to do. Stuart and I have had opportunities to speak side by side and in dialogues, and he was a guest early on in my series. And so I'm delighted to have him back because there's so much that's gone on lately, and I want to have that opportunity. So we're going to talk about rules and considerations that govern returning to work, terminations and liabilities regarding that, how to minimize the impacts on staff morale, what to do if employers refuse to return to work or they ask for accommodation, and to talk about the safety in the workplace. Um, so we'll stop the slides now, and Stuart and I are going to have a discussion. We've always done this dialogue format. We feel that it works well, and we would love to have that conversation today. So okay, Jenny, you seem to be on my screen, but I don't know if you're prominent on other people's screens. We want, I'll start off, I think the most important question that's on people's minds is you've got staff. You've either laid them off or they've been working virtually, and you need to bring them back. Stuart, let's talk a little bit about what happens when we've got people on temporary layoff and you want to recall them. Let's start with that one first, that scenario.
Yeah, actually, if you'll indulge me for a moment, I'll first of all thank you for having me back. And I was, as you were speaking before, I was just looking to check the date of the last time that I joined you. So it was April 8th, which isn't that long ago, but it's amazing how much has changed since that time. And at that point, we were really early days. We were talking a lot about layoffs and reductions in wages, reduction in hours, cost cutting. Now, of course, we're in the getting back to business phase. And every phase brings with it new issues, new challenges. The common theme, and this is the common theme throughout my 20 plus years of practice, is people get themselves into trouble when they act based upon assumptions, when they don't take the time to think about what their legal obligations and what their rights are. And when they fail to realize that employment relationships, you may look at them as your team, your staff. We look at these as legal relationships, and it's important that you do as well, because when you don't, that's when you get into trouble. And it's fascinating to see how over the last 4 or 5 months, people, employers in particular, in some ways they overestimate their rights, in some ways they underestimate their rights. And just a quick example, you mentioned, layoffs and recalls. So last time I was on, we talked a lot about layoffs, and I made the point that I was making quite frequently back then, that a lot of employers are assuming they have the right to lay people off, and in fact they didn't. So they were overestimating their rights. Now we're at the return to work phase, and people are being recalled. And the most common question that we are getting at our firm is, what happens if someone refuses to come back? And now employees are overestimating their rights, and they seem to think they have a choice. And the interesting thing is that employers are underestimating their rights, because they don't seem to think they can do anything about it. When an employee says, no, I don't want to come back yet, I'd rather stay on the CERB, I'd rather stay at home, I'm worried about my safety, they don't seem to think they can push the issue anymore. So I know we're going to talk about that, but I just want to make the general point that, these employment relationships are legal relationships, and everything we're discussing, and I know you and I often talk about this, everything we're discussing has a legal component and a practical component. And so you want to be mindful of that too, but you also don't want to shortchange yourself or expose yourself to liability. And I mean, most people I know are predicting a surge of employment related litigation coming out of this pandemic. And I fully agree with that. I think we're going to see a lot of claims. And I think, we warned people back in April that if you laid someone off, you're risking liability. And I think a lot of people now are thinking, well, it hasn't happened yet, so I think I'm okay. You're not out of the woods yet. So you need to be very, very cautious. So all the issues we're going to talk about, we should talk about the legal aspect and then the practical aspect as well. So everyone understands, basically, so everyone's making an informed decision.
And I think that's why we have that dialogue together, because it is important. And I think too often I find people don't understand what the legal ramifications are. And I always start with, talk to me with regards to the employee perspective. I know enough about law, not that everybody does, but I know enough about law to say, now you need to go to the lawyer, but at least have that initial discussion. I think it's about planning, and it's about looking at the possibilities. And if some of it whiffs of a possibility that you are going to be, sued by your staff, then you really need to incorporate that legal. But it is that balance, because you can have a situation that becomes legal, but you need to understand that you should be creating these strong relationships so that they will give you the benefit of doubt. You screw them, they're going to feel that they have an obligation to do what's best for them and their family. You can't always predict that. So let's dive in, but that's a general discussion that you need, overlying thing that you need to think about when you're making that kind of decisions. So you've got people that are coming back to work from layoffs. Let's talk about that situation, and maybe also there's the tandem one with the terminations. So some people have been terminated. So what are those kind of ramifications?
Yes, I think there's a whole lot of things to think about here. And by the way, I'm just looking at the list of people who have tuned in. It's nice to see a lot of familiar names. So one thing that's really important to understand is, especially in Ontario, uh, as an employer, if you have employees who are off work right now, the first thing you need to make sure you know is what is their legal status, because a lot of people were laid off, and we talked about the pros and cons of that. And then those layoffs were retroactively changed to leaves of absence, the IDEL, the infectious disease emergency leave, at the end of May. And the main reason for that was because temporary layoffs have a time limit, and we were getting very close to that time limit. Some provinces addressed that issue by simply extending the time limit. Ontario took a different approach and they basically converted almost all of those almost all of those layoffs into leaves of absence.
Right.
So you may think you have an employee who's been laid off. They might actually be on the IDEL. And the important thing to know about that is the IDEL lasts until 6 weeks after the state of emergency ends. That was July 24th, which means that on September 4th, you now have this very important date, which should be marked in your calendar, and then you should mark at least a few weeks ahead of that, because this generally helped employers by extending or by eliminating that time limit for layoffs. The one thing it did, though, is it converted this into a leave. And as everyone will know, if you think about pregnancy or parental leaves, at the end of the leave, you have an obligation to put the individual back in their job unless the job no longer exists. So now, come September 4th, you need to put those people back into their jobs unless the job doesn't exist, or unless there is if they have need for accommodation, they have to stay off work. That's, if they're asking to stay off work. But otherwise, you're going to need to bring them back. And I want to talk a little bit about recalls, because to my point earlier, there's so many assumptions, misconceptions, myths out there. A lot of people assume that when you recall someone from layoff, you have to do it based upon seniority, or that the first person laid off has to be the first person brought back. None of these are true. Now, I'll add a caveat here. If you are in a unionized workplace, you have a collective agreement that will set out very clear rules on how layoffs work and how the recalls work. If you're not unionized, which of course is the vast majority of employers, there are no rules as to who you recall, when you recall, or in what order. And as we've said to a lot of our clients, this is an opportunity. This is an opportunity, first of all, to assess your needs, figure out how many workers you need to have back, but then also think about who. Who are the ones you really want back? Who are the ones you don't want back? And I'll come back to that because you mentioned terminations, Hilda. A lot of our clients are taking the opportunity to go through their staff list and say, you know what, these are people that we don't really need and don't really want. And now is the time to cut our ties. So when it comes to recalls, you want to do it professionally and properly, but don't think that you're limited as to who you recall and when. And if you're going to terminate someone, then you can do that. And maybe we'll come back to this later, any termination is risky. So you want to make sure you do it properly and you give the person whatever they're entitled to. And to your point, Hilda, about morale, you don't want people to think, oh, well, they're now firing people in the middle of a pandemic and not doing and shortchanging them. So you want to do things properly, but you also have to do what's best for your business.
Yeah. And I think it's important that throughout COVID, if you haven't done it, start doing it. But I think if you've been listening to me, you know that you need to build the relationship with your staff. You need to build that trust so that they know what you're trying to do is for the best interest of the company. And sometimes that means tough decisions. That means work hour reduction. That means terminations. That means layoffs. And you're absolutely right. This, behind the scenes, it is the time to think, who are the people that I really want to keep and who are the people that I need to terminate. But if you're terminating, that's a cost. That's a big cost for sure.
It is. I usually try to portray it as an investment because long term, usually when someone calls us and they talk about dismissals, and I just had this conversation yesterday with a client, and it's been a long, hard fought, challenging battle with this particular employee, which is really an indication of why they need to get rid of this employee, because everything has been a long, hard fought battle with them. But you're going to have to pay some money unless you have just cause. And as you mentioned at the beginning, I've written a book on just cause. The book is about this thick because
Yes.
the law is so complicated and the threshold is high. So sometimes you've got to bite the bullet and pay out some money, but it's usually an investment in your HR being much better and your morale being much better in the long term.
Yes, and that's the investment is not just the monetary investment, it's the investment in your culture. Because
Mm.
when I've talked to people and they've had that difficult decision, should I terminate this person? And we spent hours talking about the impact this one person has on morale. And when they terminate that person, the energy level positively rises, the tension dissipates, and they think, we should have done that sooner. So definitely an investment.
Yeah.
Any other things? I know we need to move on, but I think this is really probably helping people. I think I just saw a question pop up
Yeah.
about favoritism. Like, okay, Jenny, do you want to ask a question related to what we've asked?
Well, actually, Aviva brought in another good idea. She asked, like, can you terminate someone and then hire someone else shortly after?
Yeah, that's the question.
Right. Yeah, that's a great question. And so this gets back again to my point about myths and assumptions out there. So
Yeah, yeah.
again, unionized workplace is very different. But if you're not unionized, it's important to start from this basic premise. You can let anybody go at any time for almost any reason. Now, I say almost because it can't be human rights. You can't let them go because of the color of their skin, their religion, their sexual orientation, etc. Aside from that, you could decide that you have an employee, and it doesn't matter if they've been there for a week or for 15 or 20 years, that you just don't want anymore. And you can let them go. And you've got to make sure you give them whatever notice or whatever severance they're entitled to. But there is nothing wrong with hiring someone else to replace them. That's actually a good business decision. So, what you want to avoid, though, is being dishonest. So, you can't say, we are terminating your employment because your position has been eliminated, and then hire someone else into the position a week later. That's going to expose you to bad faith damages. But if you just say, we're terminating your employment, period, you don't have to give a reason and then replace them. There's absolutely nothing wrong with that.
My advice to people who are trying to terminate, and I mean, it's usually disciplinary, is that you terminate them without cause. You don't explain, because that is going to minimize your risk. A lot of people think they have to explain something, and no, no, write it in with, without cause, and don't say anything during the termination phase about why.
Yeah, no, that's what I think we coach our clients in the same way, Alda. I mean, you want that, it's important to have a
Yeah,
meeting when you let someone go. And I know it's very awkward now in the virtual pandemic world, but still, it's important to meet face to face. But you want that meeting to be 5 minutes, short and sweet. And you're not going to get sucked into a discussion of why, or will you change your mind, or will you give me a second chance? You're just, the decision is final. You don't have to give a reason. If you're firing someone for cause, then you're going to need to give a reason, but 98% of dismissals in Canada are without cause, in which case you don't need to give a reason. So don't get drawn into that discussion.
right. And do seek guidance, either your HR professional that's in your organization, or your a lawyer, or even a consultant, for sure,
Yeah,
because
and
doing it
just
on your own is sometimes exposes you to a bit of risk. Get some advice on
yeah,
how
no,
to
and
deal with
I
it.
would say it even more stronger. I mean,
Okay.
you want to have your HR consultant or your HR person in-house or external. You also want to have your employment lawyer.
Yeah,
And getting back
yeah,
to myths, I mean, the biggest myth out there in employment law is that severance is 1 month per year. That is not the law, and it can be a lot more. It can be a lot less.
yeah.
So don't overpay, but also don't underpay, or you're just going to expose yourself to a claim. I mean, what we normally do if we have a client who is going to let someone go, the first thing we do is we'll give them a proper opinion as to what this person's entitlement might be. And we'll also explain the options, because contrary to popular belief, it doesn't have to be a package. It doesn't have to be a lump sum. It could be a working notice in some cases. It could be a combination. So we'll explain the options, and then our client will make an informed decision as to how they want to do it, and then we'll document it properly and figure out the best way to do things. But it's really important to get that advice up front, because it's always going to cost you more to fix it later than it will to do it properly to begin with. So I really encourage people to do that. And just on the dismissal front, as like Hilda said, I mean, you need someone like Hilda to guide you through the process, get the legal advice, and get the coaching so you do it properly.
Yeah, yeah. I always say that, here's once we sort out the letter, is that more important is that discussion that you have, that 5 minute discussion. And even afterwards, I call them up and say, how are you doing and how you're feeling? Because there's emotions of delivering that message that is held on them. So I really want that to kind of dissipate, and just give them a chat afterwards, for sure. I know we could talk hours just on this one topic, but I want to make sure people kind of have a good glimpse of what the options are. So let's talk about the people that kind of refuse to go back to work, and that's a strong word, but they say, no, I can't go back because of my child, or I can't go back because I have health issues, or I can't go back because I'm worried for safety. So let's talk about those different combinations, because you said unlike what happens is employees think they have more rights and employers think they have less rights when it comes to, we want you to return to work, answer, 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 so how do I respond? So let's talk about that for a little
Yeah, I mean, like I
bit.
said, this is the most common question we're getting. It's been interesting for the last 3 months. I've been on 680 News on a fairly regular basis as their go-to employment lawyer, and they're taking questions. If you listen at all, you hear it 680 gets answers. And so they're taking listener questions. And the most common question is, do I have to go back to work when I'm recalled? And it's fascinating to me that people seem to think that work is optional now. And you know, the explanation I've been giving quite often lately is like, let's assume in pre-COVID times, if you go to work on Monday, you go to work on Tuesday, you can't just decide you're not going to go to work for the rest of the week. And that's basically the same as if you've been on layoff for the last 2 months and now you've been recalled to work. If you are recalled to work, you have to go back. It's not optional. Now, there are three exceptions to this, or three exemptions, I guess. One is the entitlement to a leave. So in pretty well every province, including Ontario, there are leaves of absence for people who are unable to work due to COVID-19. And I stress the word unable, not unwilling or prefer not to. So they may be entitled to a leave of absence. Then, of course, we've got human rights legislation in every province, which says everyone is entitled to accommodation where there is a need for accommodation. So again, I'm stressing the word need, not a preference. It could be childcare related. It could be because they have some sort of medical condition that makes them more susceptible than others. But, and we can talk about this more if we have time, they're going to have to demonstrate that need. The request for accommodation should be the start of the dialogue, not the end of the discussion. And they're going to have to show you that there is a need for accommodation. And then you can assess, whether, first of all, whether it's legitimate, and second of all, how you can accommodate them. And the third exception is the right to refuse unsafe work. So if the workplace is unsafe, and this is nothing new for COVID, this has always existed, people can refuse to work. Those are the three exceptions. Unless they fall within one of those, then they are obligated to work. And we've been working with a lot of our clients lately, first of all, to explain that yes, you can insist that someone come back, and then helping them to handle the situation. And the first step is usually, and I know this is along the lines of what you would say, Hilda, it's communication. Right? If someone says, I'm not coming back, or someone just says no, find out why. Find out what's going on. Is there a real medical issue? Is there a childcare issue? Is it just that they are scared to go out in public? And then you can assess if they have a need for accommodation or otherwise, or you can also talk to them and reassure them, because I've seen this a few times where people have said, well, I'm not really convinced that the workplace is safe. And if you can show them what you are doing to make sure the workplace is safe, then you can often make them realize that yes, it is okay for them to come back to work, and then they will come back.
And it's sometimes just hearing and listening to those fears. Like, I'm afraid to come back to work because I don't even want to take the public transportation. And you can walk through and help understand and support that, to the extent. And that brings me back to this accommodation, which I know you would have mentioned, but I want to make sure people hear this. When a person comes to you and you with a need for accommodation, what you need to do is, it's a collaborative approach. It is not, I need this, this, and this, and you say, okay, yeah, we can do that, up to the point of undue hardship. But the point is, you are the employer and you know your work situation. What you need to do is say, yeah, we can manage these things, but this one's going to be a little bit tough because it's going to leave me at risk of not having enough staff. What can we do to make sure the needs of the company are there, but I respect and manage your needs? So what can we do to kind of collaborate and come up with a solution that's good for both of us? And so that means, don't feel that when they come with a duty to accommodate that you have to comply with everything on the checklist.
Yeah, thank you for saying that, because I think it's a really important point. First of all, you need to assess if there is even a need to accommodate.
Mm-hmm.
But if there is, then you are entitled to assess what the options are for accommodation, and the employee doesn't get to insist upon a specific type. I mean, in this context, we're often talking about staying at home, and people say, I want to be, or they won't say I need to be accommodated by staying at home. They're just going to say, I want to stay at home, or I need to stay at home. But you're entitled to engage in that dialogue and find out why, and then assess the risks. And I'll give you a great example. We helped a client with this a few weeks ago now, where they had an individual who was immunocompromised. and their doctor advised them that, and all the evidence was that the workplace had been cleaned, it was safe. The concern was taking public transportation to get to work. And that her doctor had said that she should not be on the bus in rush hour. So there was a very extensive discussions involving the individual, HR, her doctor. And what they eventually realized was that in non-peak hours, the doctor said it would be okay for her to take the bus. So the accommodation went from, I need to stay at home, to, we'll just modify your hours. And that was all it took, modifying her hours so she wasn't on the bus during rush hour and she was able to return to work. So to your point, it's got to be a dialogue, and you may find there is a very simple solution.
So here's an interesting one, and then I think we'll shift from talking about accommodation and layoffs. Some people, when they dialogue back, it's CERB, right? They just got the window and they've been paid for their check, and now they're asked to come back to work, and that's during the period.
Hmm.
So some companies are sort of saying, well, I can't have you wait until the period's over. I need you to start back now. Solution's probably simple, but I think people will be asking this question. So what would your advice be? And there are some people that kind of put the hours less during that period to accommodate the minimum amount that you can work. So interesting
Yeah.
scenarios.
Yeah, and look, I mean, this has obviously become an issue, and this is, I think some people have said the CERB is a bit of a disincentive to working for some people, and I think that is a minority of people. But nevertheless, I mean, to your question, if you've been paid for a period and that you've now been recalled, the simple answer is you've got to repay some or all of it. And I know I haven't looked at the stats lately, but last time I looked, it was hundreds of thousands of people have already repaid money on the CERB, and the government will make it very easy for you to repay the money. So if you go to the CRA website, you can find out exactly how to do it, as opposed to not repaying it. And at some point, it's been very clear from CRA they are going to start reviewing all these files, and they will come after you for the money. So the simplest thing to do is just repay whatever. Go to the website, find out what your repayment obligation is, find out how to do it, and repay it. If your employer is willing to be flexible and say, well, you can delay your return, then you can look at doing that, or you can minimize, because of course you can earn up to a certain amount of money without having to repay. If that's possible, then you can do that. But otherwise, the simple answer is, it's not supposed to be a case where you're being paid and getting the CERB. So if you are now back at work, then just figure out what your repayment option or obligation is.
So CERB has certainly been helpful for individuals and their families to give them peace of mind. And there's a host of things that have happened for employers and companies. And I will just make one mention of the CEBA. So that's the $40,000, and the CEWS, the wage subsidies. If you looked at it back in April and said, oops, I don't qualify, and have not kept abreast, it has gone through at least 6 different reiterations, particularly in the case of the CEWS or CEWS. So do go back and do find out whether you apply. It's applicable for you, because there's been so many changes. I know I put a post on that to go look. I think you did as well. And you have your own COVID-19 website. So do check things out. I like CFIB, Canadian Federation of Independent Businesses, because I can go to their site, I can look up CEWS, click on it, and then I can see what the latest is. But do go. If you have not gone and you think you're not eligible, you now may be eligible.
That's a great point, Hilda. And thank you for the plug, by the way. We do have a COVID-19 resource page on our website. So I do encourage everyone to go to our website. It's rudnerlaw.ca, and you'll see a banner will come up at the top to encourage you to check out our COVID-19 resource page. Check it out. But also, because things keep changing so rapidly, so we update that quite often. We also have social media where we try to post all the latest iterations. But you make a great point. The Qs or SUs or whatever you call it has changed over and over again, and we're now in a whole new stage. And they're now trying to wean people off of it,
Right.
because it will end at the end of the year. But they've also expanded it. So people that were, to your point, people that weren't eligible before may be eligible now. Before, you had to have a reduction in revenue of at least 30%. That requirement doesn't exist as of period 5. So you can qualify even if your drop in revenue was less. They've now divided the subsidy into 2. You've got your sort of basic subsidy, and then a top up if you have had an even greater decrease in revenue. And the numbers will change between now and the end of the year. So
And you
and
can,
you need to have an accountant to fully understand
I
it.
was going to just say that. I thought, oh, thank God, I've got my accountant working on it now. But I think, I, yeah, 'cause it just keeps changing, and it is kind of titrating down. But I want to remind you, it's retroactive. So if you look back, and you can still go back to March, based on things. So again, too much detail for us to discuss here, but do go check it out, because you may be eligible. And it's certainly given me peace of mind from cash flow perspective to just keep going. Jenny says Aviva will oh, sorry, that's a question. I want to now kind of go into the safety aspects. I saw Maria pop up a question with regards to face mask and droplets. So, people are asking, are people obligated to wear face masks? Jenny, can you
Yeah,
bring
no,
that question up?
I'll chime in on that. There are two questions that are in the group chat. It's very good.
Good.
One is actually about calling in sick when workers are back to work. Like, can they do that? Yes, employers have to keep their employees home if they aren't feeling sick. But what if employees are taking advantage of this calling in sick during COVID-19, right? And then, as you were saying, Maria Collins had a great, I mean, not great, but like a situation where employees are refusing to wear masks, and they're citing that the doctor said he has asthma and cannot wear a mask, right? Even though he has not had any exacerbation. Sorry about that. So yeah, like, however, since he is refusing to protect customers, what risk do we have to terminate this person?
Yeah, interesting questions, both good questions. So I guess I'll take a step back first. So it's important to remember that your obligation as an employer is to take all reasonable steps to ensure that you have a safe workplace. So there is no one size fits all. Every workplace is different. Every situation has to be assessed based upon its own particular factors. And even within a workplace, you can have different sets of rules. So we have clients where some of their employees can work effectively from home. So some of them are just going to keep working remotely. Some have to be in the workplace, but they can remain physically distant. And some are in the workplace, but are going to have to be closer to either colleagues or customers or suppliers or other people. And so the provisions you put in place there to maintain safety will be different, obviously, for each group. But you are entitled to put rules in place to ensure safety. And I can tell you, again, from having written the book that we talked about before, and I should mention it's a loose leaf, which means it's never actually finished. Which means that I'm updating it twice a year, and I review every single just cause case, either court or arbitrator. And I can tell you that over the last few years, I've seen a number of cases where people have been dismissed for breaching safety policies. And safety policies will get a lot of deference from judges. It's one thing if you say you have a policy, but if you have a safety policy,
Yep, over there.
judges are more. Oh, sorry.
Thank you.
Background noise.
So it's gonna
Can
get
somebody
picked up by the
mute?
end of the
Somebody,
day,
we can
and
hear you. The lady with the black face mask, you're
Oh,
showing
there they
up.
go. I think we're on mute now.
Thank you.
Okay, so I was just saying courts will be much more likely to uphold a dismissal where someone is breaching a safety policy for obvious reasons. They understand how important safety is. You're always going to have to, first of all, justify that the policy is reasonable. And you're also going to have to show that the employee was made aware of it and given some warning, some opportunity to correct their behavior. But if it's reasonable to insist, for example, someone wear a mask and they refuse, then, and despite the warning, they continue to refuse, you may have just cause. If they, I know you, Jenny, you mentioned that the questioner mentioned asthma. If they have a need for accommodation, as Hilda and I talked about, this is going to have to be a dialogue. They're going to have to produce some documentation to show the need for accommodation, and then you can assess whether they actually have to be accommodated or not. But they can't just come in and say, I have asthma, I'm not wearing a mask, and think that's the end of the discussion. They're going to have to justify that, and then you may have to accommodate them if they can produce documentation, which might involve allowing them to not wear a mask, but then you can't put other people at risk. So it might also involve allowing them to work from home, or it might be a leave of absence if nothing else is viable. But that's going to be an ongoing dialogue. And actually, before we get to the other question, did you want to add to
It
that,
can,
Hilda?
it can be even teaching them maybe some techniques to help them breathe and relax behind the mask. Because, having been a nurse in my prior lifetime, I know how asthmatics are. They get really scared. And when you get scared, you start, hyperventilating more and breathing. And so it's learning how to de-escalate that. And maybe it's teaching them how to breathe with a mask. So that may be just a simple solution that people hadn't even thought about.
I like the simple solutions. But you know what? I mean, it gets to the point we're making.
Maybe not for the breather, but it sounds simple.
Look, it might be, but there might be a simple solution. So it's all about talking this through, and it's often a three-way dialogue because it often should be
Yeah.
their doctor involved as well to figure out how we can make this work. So talk that through, but ultimately, if they do need accommodation, then you may have to accommodate them to the point of undue hardship. So you'll have to look at ways to do that, which might mean just reassigning duties. Maybe they can work in the back where they're not in contact with people and don't need to wear a mask. So you need to assess that. And then the other question, which I thought was interesting, was people calling in sick and essentially abusing the situation. Which, I mean, as Jenny, as you're reading the question, I was sort of thinking to myself about this because I haven't really seen this question come up yet. But really, it's no different than pre-COVID times. If you can remember pre-COVID times, sick leave is something that is sort of what I think of as something that you should be providing to employees. If someone is sick, they should be allowed to stay home. But like anything else, you will have a small percentage of people who will abuse the situation. We're all familiar with those employees who are often sick on the Friday before a long weekend in the summer. And so again, if there's suspicious absences, you are entitled to ask for doctor's notes. And I know this is a contentious issue. It was contentious before COVID. It's even more contentious now. But at some point, you are entitled as an employer to ask for documentation to support absences, especially when they're suspicious. I don't recommend doing it for every single absence, but I would also encourage everyone on this call to check your sick leave policy, because way too many companies have policies which say that if someone is absent for 3 or more days, then we will require a doctor's note. But that doesn't give you any discretion if someone has suspicious absences that are less than 3 days.
Mhm.
So leave yourself discretion and say that we're entitled to ask for doctor's notes. If we have reason to believe that there may be concern or otherwise, just leave yourself discretion and then ask for it. Don't be abusive, but if you have a legitimate reason to be suspicious, you can ask for documentation.
Cool. I'm respectful of people's time. We did block off this day till 10:45, but Stuart and I are willing to stay on for any extra questions. I do want to spend a few more minutes talking about this morale, work culture, and mental health. The Mood Society of Canada, as well as Canadian Mental Health Association, have basically said that depression will be the number two cause of disabilities and illness in 2020, and COVID-19 being a primary reason. So I think it behooves companies to really think about the mental health of their companies, to think about creating positive work cultures. What are your thoughts on this, Stuart?
Yeah, look, I think this is probably more your domain than mine, but I think it's really important. And that's, one way where I think I really try to encourage our team to, I guess, differentiate ourselves from other law firms, because we're not only talking about the law. So as much as we will make sure people understand their legal rights or obligations, there's also a business behind this. There's personal relationships, there's a morale, there's a culture that you need to be aware of. So every decision should be made with all of those things in mind. And I mean, I agree. We're going through such strange times. And in some ways, some people are quite happy now because they're working at home. They're spending more time with their family. For some people, it's not a bad thing. For others, it's a really, really bad time. And employers need to be aware of that, so that they can deal with it. And it's often hard to know what you don't know, but employers should be mindful of that risk because it is a big one.
Yeah, for sure, for sure. And I think people should be thinking about what they can do. I think the message here is that as HR decision makers, as managers, and as business owners, you need to think long term. When you're making decisions, that have risk from a legal perspective, from a morale perspective, think of those and plan. Don't just kind of kind of react and think only 2 steps ahead. Through COVID, you need to think 5, 10 steps ahead, and post-COVID. I think we should open it up for some questions right now, Jenny, that I know you've been kind of bringing them in slowly, but are some of the, bring us back some of the ones that you've been wanting us to answer.
Well, there's been a lot of great questions here. Very
And we want to entertain some of those.
right. There is a question for the team. So this person has been laid off since March. Now that the emergency orders have been lifted, this September is the new date by which the employer must recall this person, essentially, or he would be terminated. What steps should he or she take, and what are my rights if that date comes and no one from my employer reaches out to me? Am I deemed to be automatically terminated and therefore entitled to my termination pay after that date?
Great question. And we don't really have clear answers at this point. I mean, all this is very new, but so just to play this out. So assuming that they're on leave, which was then converted to the IDEL. So they were laid off, then it was converted to a leave. As of September 4th, that leave ends, which, as I said before, means they should be brought back to work. If they're not brought back to work, then the employer could put them back on a layoff. But as Hilda, you and I talked about back in April, layoff could be a constructive dismissal. So I think one thing to remember here, you won't be automatically deemed to be terminated at that point. So it's important to engage in discussion with your employer, find out what's going on. Are you coming back? Do they propose to lay you off? Do you need to stay on a leave, which doesn't sound like you do? And if they intend to put you back on a layoff, you should think about whether you want to accept that or not, because they may not have the right to put you on a layoff. And I would definitely, I know it sounds self-serving, definitely encourage you to speak to an employment lawyer before you make that decision, because you need to know what the risks are. And a lot of people who were laid off chose to accept a bit of a short-term loss to maintain the relationship, but you'll need to make an informed decision. There won't be a deemed termination, so it's not automatic. You will have to assess what's going on and then decide what you want to do about it.
I think these are such difficult times, and even for lawyers and HR experts, it's hard to predict what you should be advising when the ground rules keep changing due to COVID-19. I think you and I had that dialogue back in April with regards to what will people do when they are now, they're being recalled, but or even terminated. Can they then sue for constructive dismissal? And in Ontario, that is unless you had it in your contract, and like maybe 2% of people had a contract provision with layoffs because everyone said it's not going to happen. And so what to do. And then I had a person come to me and said, Hilda, I've just been terminated and I'm on mat leave. And I'm going, that doesn't sound very good. I actually sent you to that person, and I said, I'm not sure how to advise on that, really, because in pre-COVID times, you have a right. There's some concerns here. But during COVID, that doesn't sound like they should have done that, first of all. Maybe they didn't know they shouldn't have done that. So it was a very, very interesting case that I was happy to send them over to you, Stuart, because I'm going, oh. Any other questions, Jenny?
Yeah, sure. We have a question about termination again. It's about like a employee who has been around for a while, and the employer wants to, the employee needs to go, right? So this employee has also signed an employment agreement. What do you suggest the employer to do in this situation?
Okay, so if I understand right, the employer has decided basically it's time for this employee to go, but there is an employment agreement in place.
No, it's actually the other way around. The employee wants to go, I think. And Sarah, feel free to clarify if anything. But the employee has been around for a long time, but signed an employee agreement.
Okay, and I'm not sure if you can tell, Jenny, is this question coming from the employee or the employer?
Employer, I believe.
Okay.
It's my question. Sorry to jump in.
Go ahead.
Thank you.
So my name is Sarah Bibb. I'm an independent HR consultant, and I had a client question. So they're a salon. So they were off on the layoff for a while, and now they've been looking to come back. But this employee's been with them for 18 years. They do not have an employment contract in place. And they've had many issues with this employee for a very, very long time, but nothing's been done. So if they do want to terminate the person, but there's no employment contract in place, I'm guessing the best thing for them to do is just make sure that they give this long-term employee exactly what they're entitled to, because there's no contract in place.
Yes and no. And I guess the problem is it's hard to know exactly what they're entitled to, because, and I don't want to digress too far on this point, but it's an important one because it's so common. Most employees don't have contracts. And
That's
even the ones
scary.
that do, most termination clauses are not enforceable. We had another decision from the Court of Appeal a month ago, which means that a lot of termination clauses are now unenforceable anyways. So they're governed by the common law. The common law says that they're entitled to reasonable notice. And the common myth out there is a month per year, but our courts have said over and over again, they're going to look at a lot of factors, including length of service, age, nature of their job, availability of similar position, et cetera. And so what we do, we've developed an artificial intelligence solution, we entered 24 pieces of data, and it will compare those pieces of data to all the case law from the last 40 or 50 years. And it will try to assess what is most likely to happen if they go to court. And it'll give you an estimate between, about a month's range. So let's say 16 to 17 months or 13 to 14 months. So what we do with our clients, we will say, look, if this person were to go to court, they're most likely going to get between X and Y. So now let's figure out what you want to offer them, but also how. Do you want to give them working notice? Do you want to give them a lump sum? Do you want to give them salary continuance with a clawback, without a clawback? We'll figure out the best strategy. So there's a lot of options, but you want to make sure, I agree with you, Sarah, they want to make sure they're getting the right advice so they can make a decision that isn't going to expose them to risk.
Thank you.
I think that's really a good point to share some of the broad parameters, because I think that's the key, that when I get talking to some of my clients, that they say, what do we do? And I give them those broad ideas so that they have some idea as they're planning what they do, and getting down to the details will help them make that decision. But certainly having that generalities initially. I want to go to our slides to finish off that, and then finish off with any questions other people may have. I think this has been a really lively discussion today, as you and I always have lively. I remember the time I was on your Fire Away, and you said this is the first time anybody's actually had this opposite kind of opinion on my show, and I said, oh, sorry.
No,
Was
it's a
that?
good thing.
But I think you and I have this respect for each other and our roles, and really help our listeners understand both sides when they're trying to make those decisions. I just wanted to share with you, as I said, we've been on 23 episodes. Today's our 24th, and these are the links to it. As people who are listening in, who've registered, you will get a copy both of the YouTube presentation as well as the slides to look at. And we continue to do this. We just launched our newest website, updated it to reflect some of the activities we're doing. So all of our episodes are there in our Knowledge Vault for you to click on and go directly to. The next slide, Jenny. I just wanted to say that as People Bright, we can certainly help. I do offer a free 30-minute discovery call with you. So do go to my website and look it up, or here's where my Calendly link is. I want to ask Stuart, how do people connect with you? I know you've said it before, but how do people connect with you? And is there something that you want to share about what you're up to lately?
Yeah, thanks, Alda. Well, not surprising, what we're up to is a lot of advice on COVID-19 related issues. So as we mentioned, or you mentioned, we have a COVID-19 resource page on our website. We also have very active social media, and we have a newsletter, and you can access all of these things from the website. So rudnerlaw.ca is the place to go, or Google Rudner Law or Stuart Rudner. You'll find us very easily. I will mention the one thing in particular, which is we put together a guide to getting back to work, which is about 30 pages long. And
I remember seeing that.
yeah,
Kudos to you for that.
Oh, thank you. I mean, the sad part is that after all that work, I mean, so much has changed since
Oh,
then that
right.
not everything in there is perfectly accurate anymore. Like the cues, for example, has changed, but the vast majority I think is very helpful. So feel free to reach out to us. We're happy to send you a PDF copy of that. And the last thing I'll say is feel free to reach out if you have questions. I don't have a formal 30-minute discovery call like you have, Hilda. I love the way I love what you called that. But I'm happy to chat with people. So if you think you might need some advice, feel free to reach out. Happy to chat. If we can help you, that's great. If not, there's no harm done. But again, I know I've said this before today. It's really important people make informed decisions. Don't make assumptions about what your rights are or what they're not. I'm always warning people about making decisions and exposing themselves to liability. But it's equally important that you not make decisions and shortchange yourself.
Yeah.
So make sure to make informed decisions. And so again, rudnerlaw.ca is the best way to find me, or Stuart@rudnerlaw.ca is my email. And I'd be happy to chat about a lot of the issues that people are facing these days.
We can stop the slides now, Jenny. So I really appreciate that we had 50 plus registrations today and 30 showed up. So we usually get a really good turnout, and I'm really pleased that people found that this is valuable. Oh, one more slide. Thank you, Jenny. We do offer our sessions every Wednesday, but for the summer we kind of slowed down, and so we are going to hold two ones upcoming. The next one is actually bullying and harassment, how to make it stop. I am so tired of hearing people who have policies and procedures and people cannot feel comfortable going forward. So that's my little kind of soapbox piece, but I will be talking about bullying and harassment on Wednesday, August the 26th from 10 to 10:45, and then 2 weeks later episode 26 is on how to deal with toxic work cultures. As I mentioned, I am a work culture expert, and I really do want to help companies, and we'll focus on toxic work cultures on September 9th. So let's take it back and answer any other questions people have. As I said, Stuart has been kind to stay on for a little bit longer so that we have some questions. What's your time like? Is ending at the hour? 5 more minutes
It's
good?
amazing how fast the time goes by, but yeah, I think stick around till 11 to be fine.
Yeah. All
And
right.
one thing I'll throw in really quickly. So I have my monthly online show. It's called Fire Away. It's next Tuesday is the next episode, and we're going to be focusing on workplace harassment and bullying as well. And we have a woman who's a lawyer, but also an expert, and has spent, I believe, 30 years in practice dealing with not only workplace harassment, but other forms of harassment and bullying. So it should be a really great show. So next Tuesday at 12:30 we go live. It's called Fire Away. So feel free to tune into that as well. And as I'll
I
start
think
talking,
that
so we can at least have a few more minutes for questions.
I think that will be so interesting because I think so many people are hearing about, situations and, oh, we didn't have any incidences. Really? Well, because your culture probably doesn't allow people to have, to come forward, or people think HR is not going to do anything about it.
Yeah.
So I want you to have your time to say something, and I certainly want to have my time. What are the questions, Jenny, that have come forward?
Yeah, near Rami, sorry, said we have a full-time employee who they want to bring back on part-time hours before the layoff becomes permanent. Does the employee have to agree to the part-time hours?
Good question.
Yeah, that is a great question, and another one of the most common ones, and another one of the potentially most common mistakes, because a lot of employers are saying, "Well, we're ready to start bringing people back," and it's totally understandable because a lot of companies are not; they can't go from 0 to 100 overnight, so they're not ready to ramp up fully. So they want to bring people back part time, reduced hours. The problem with that is you don't necessarily have the right to just change someone's contract. And the analogy I often use is rent or dealing with your landlord. Nobody would go to their landlord and say, "I know that our monthly rent is $20,000, but going forward, we're just going to give you 10." And yet those same people will go to their employees and say, "I know that you were working 40 hours a week, but going forward, it's only going to be 20." You don't have the right to change. It's a legal contract. And like I keep saying, the employment relationship is a legal relationship. So you're dealing with constructive dismissal, which we could spend the next 2 hours talking about. But very simply, a constructive dismissal is a unilateral and substantial change to a fundamental term of the relationship. Hours of work are most definitely a fundamental term. So the question is whether this is substantial. So if it's a nominal change, if you're going from let's say a 40-hour week to a 38-hour week. And that's probably not enough of a change to be a risk. But if you're going from 40 to 20 or something like that, that may well be a substantial change, in which case the person could claim constructive dismissal. And ideally, what you'd want to do is get the person to sign off and agree to it and accept the change rather than just impose it upon them, because then you could be open to a claim.
I heard something in terms of percentages that if it was 10 or 20%, I think, that wasn't considered it could be fine in terms of not substantive. Do you know those numbers, Stuart?
I know the same myths.
Okay, myths. Thank you.
And here's the problem. You will never find a law that says this.
Yes, of
So
course.
if you look at the legal jurisprudence, though, you will see that generally, if it's less than 10%, most courts have said it's not a substantial change. If you get beyond 20%, usually is. Between 10 and 20 is a bit of the gray area, but every case will be decided on its own particular facts. So don't assume that's the law. There is no law that says this.
Yeah.
But like I said, a minor change is okay.
I think our dialogue today was to really give people an idea of some of the things that they need to think about. And as much as you and I can give people advice, the long and short of it is you're dealing with people. So you cannot predict how that person is going to respond. What our role is to help you go in with eyes wider open
Yes.
and give you advice. But will that advice, hold true? No, because you are dealing with people. In the time that we had our company, we had probably 3 people when we terminated people for not for cause. Out of the number we had, maybe 20 over the course of 10 years, 3 people decided to go to a lawyer. And a couple of them were surprises to me. And then there were a couple that I thought might, but never did. So again, you cannot predict, but get the advice that you need. Think it through as you do it, and that will help you minimize risk. There's
Yeah.
there's no absolute guarantee that this won't happen, but it's minimizing risk. Other
Yeah.
questions, or you wanted to comment on my thoughts?
No, I think it's a great point. I mean, there's never any guarantees, but we can definitely reduce
Yeah.
and minimize risk if we do
Right.
things properly.
Yeah,
Jenny,
another question from Adele.
I
How
think
long
that'll
can
be
you
the
delay
last one.
Sure. How long can you delay a return for an employee that requires accommodation? For example, this employee has elder care issues and is unable to return to the workplace for fear of exposure.
Yeah, so it's a great accommodation question. So if they have a legitimate need for accommodation, and you are entitled to explore that, I mean, you mentioned elder care, so they would have to show that there are no other options, that this isn't just a preference. But if they have a need, then accommodation can last for months, can last for years. But again, it's not open to the employee to dictate. So at some point you might say, we think we can accommodate you in a different way. Maybe it's working from home. Maybe that will accommodate the person so they can provide the care to their parents or to whoever needs it. Or maybe you can adjust their hours. There may be other ways to accommodate them. Otherwise, you're also getting to the point of undue hardship. You have to accommodate up to that point. But undue hardship is a high threshold. It will depend very much on the nature of your business. For example, if you are a business with 3 people and one of them is off work for accommodation for an extended period of time, that might be undue hardship. If you are a business of 2,000 people and one of them is off work, it's probably not going to be undue hardship. So you're going to have to assess it on a case-by-case basis, but also assess whether there's a different way to accommodate other than just having them stay home.
On that question, it is just after 11. I appreciate everybody's time. We've still got 25 participants staying on because these questions, I think, have been so valuable and helpful to people as they think through some of the situations. I see Sarah's giving a big hand clap for things. So thank you very much, Stuart, for joining me. I would also be remiss if I didn't acknowledge East Gwillimbury Chamber of Commerce. They have been sponsoring us probably since June or May now on our sessions, and certainly send it out to their readership. So thank you very much, everybody, for taking the time to join us today, and Stuart, especially to you. It's been a pleasure. I always enjoy our discussions, and we can catch up together. So thank you very much.
Yeah, thanks for having me, Hilda. Thanks for everyone, and I see a lot of familiar names and faces. And
I know.
have a great day,
Lots of
everyone.
familiar people. Thank you.